Welcome to the What Makes a Great Trial Judge podcast, part of the Lawyer Minds ecosystem. We've paired up with Lisa Blue, a practicing psychologist of 46 years and trial attorney of 44 years, to discuss some of the ways trial judges, especially those dealing with trauma-intensive cases, can improve their techniques and social practices, making the litigation experience more meaningful for jurors and litigants alike. So, how do you tell the difference between a great trial judge and one who needs to work on their social intelligence skills? Let's find out. We'll be interviewing some of the greatest trial judges around who offer tips for improvement and share their secrets. And with that, here's your host, Lisa Blue.
Good morning, Lisa.
Mark Lanier, how did I get so lucky to interview you?
How did I get so lucky to be interviewed by you?
Mark, I don't know anybody else who has gotten the kind of verdicts you've gotten, who has tried more cases, state and federal, in as many states as you. So as you know, what we're here to do today is talk about your experience and what makes a great trial judge and things that maybe aren't such a great look. So before we do that, let's talk a little bit about your background and then get into your trial experience.
Okay, well, I'm one of three children to my mom and dad, and I am in that middle position. So I guess I suffer from middle child syndrome, which is supposed to make us people who work really, really hard to merit praise and attention. Because we're the middle child. We're not the oldest, we're not the youngest. I certainly growing up felt fully loved, but also fully engaged to try and use any gifts and abilities and talents I had for a greater good than just personal gain. And so I studied hard, studied to be either in the ministry as a preacher or to be in law as a trial lawyer, wound up kind of qualifying for both. So by profession, I practice law and try cases. By passion, I still continue to preach and teach. The trial practice took me initially to one of the big firms. So I was a defense attorney for 5.5 years at what was then called Fulbright and Jaworski. It has subsequently changed names. I think now it's Norton Rose Fulbright. And it was a wonderful time in the early to mid 80s to be there because we had big dockets for people like me. So I had about 175 cases on my own docket when I left. I had tried already dozens of cases and mostly in Texas at that point, though I did cross over and do some nearby and had practiced in New Mexico and Oklahoma and Louisiana at that point. I loved it. I loved what I did, but I had a calling to go out on my own and to start working as a plaintiff's attorney. And that's what I did from there for the last, over 30 years. I guess I started my firm in 1990. And I have I do some defense work still, but most of my work is plaintiff's work. I've tried cases all around the country. I've been in the trial in courtrooms from California to New York and all places in between, from the northern border up in Illinois, down Chicago, down to Texas, and like I say, all points in between, state courts and federal courts in all of the places that I've been.
How long have you been a practicing lawyer?
I got out of law school in May of 1984. And so I started at Fulbright June 1, 1984.
And how many civil cases do you think you've tried in your career since 1984?
Lisa, I've lost track of them. I know it's in the hundreds. I've kept track of the long ones. I added up recently that I've tried 13 cases that have gone into 3 months. So that's basically 39 months of trial that I've been through in the big cases. But I've tried countless little cases. Heavens, I tried cases in small claims court. I tried my first case when I was a junior in high school, and I'd gotten a moving violation I didn't think I deserved. And I went pro se defense, picking a jury and everything else in Lubbock, Texas municipal court. I've tried all sorts of cases. I've tried every kind of malpractice, from medical to architectural to engineering malpractice. I have tried all sorts of product liability cases, those in the MDLs and those in the one-offs. I've tried those from both sides of the bar. I've tried countless FELA cases. I've tried railroad crossing fatalities. I've tried offshore injuries. I've tried commercial cases, fraud cases, breach of contract cases, breach of warranty cases. I've tried just about every kind of case you can think of, except criminal. I have not done criminal work, and I've not done family law work. I'd rather take a beating than try a family law case.
You know, you mentioned all these different trials. Since I've known you for about 40 years, what people may not know about you, the judges that are listening to this, is in the long cases, and they're typically the ones that I know about are about 3 months. You do everything. And I mean everything, except maybe recently your daughter will take a few witnesses. Maybe one young lawyer will take a witness or two, but in all the other cases, it's 100% Mark Lanier for all those years you've been practicing, right?
Yeah. I have great support people that I couldn't do it without. Like I use you to pick a jury. I couldn't do it without you and Robert Hirschhorn and Bob Leone and people who've helped me. But in terms of standing up in front of the judge and in front of the jury, I try to do that 99% of the time, because there is a familiarity, not just with the facts and the themes and the danger flashpoints, but there's a familiarity that develops with the jury and with the judge, where you're a known quantity and they know what's going to happen when you get up there, because you are consistent and you are who you are, hopefully authentic, and it makes it work better in a way. It's a comfort zone for everyone involved in the trial. Now, I do take seriously the responsibility for teaching and grooming the next generation. And so if I've got young lawyers, whether one of my daughters or another young lawyer, I'll try to integrate them in some way where the jury realizes this is an educational moment as well as an important trial moment, or where the judge makes that realization, because it's important for everyone that we not only secure justice today, but that we enable the system to secure justice more readily tomorrow. And I think that's a responsibility, as I'm getting older, I realize is important.
Right. And I know you're married to a lawyer. You have 5 kids, 2 are lawyers, correct?
Yeah, so actually what we've got now, Rachel is a lawyer. Sarah, our daughter, is at the University of Texas Law School. She's a 2L as we're taping this. In fact, won nationals in moot court, mock trial last fall at her law school, University of Texas, one dear to you. And then she has just won the regional moot court competition and will go to nationals in that later on this semester. So we've got her upcoming. Then I've also, our son, who's already got a PhD in philosophy and logic from Oxford, has now gone to NYU Law School, and he's a 2L as well.
Right.
And so he's pursuing a law degree. We've got a daughter-in-law that graduates with a law degree in a couple of months. And we're, as Rachel says, Dad, we're the Von Trapp family lawyers.
Right. I wanted the judges to remember that about you. So before we get to the substance, I just have to point this out because it's so meaningful. You actually have your own full church on Sunday, and you have this wonderful YouTube every single day since COVID, unless I'm mistaken, called Biblical Literacy, where you talk for 5 minutes about a verse of the Bible, and you make it so creative. So you're a lawyer, but you're also a practicing minister.
Yeah, and I'm published, in the legal arena, obviously, but I'm really stoked. I'm putting the finishing touches on my 7th book in the arena of faith right now. So I kind of walk with one leg in each world, and I have a degree in Hebrew and Greek, though my emphasis was Hebrew. And so I enjoy reading the Old Testament in Hebrew and translating it. I enjoy reading the New Testament in Greek and translating it. And so that's my passion. But it's not I don't take money from it. That's not it's not a financial arrangement. I don't take money at church. I don't take royalties on the books. It's my passion, my profession that pays for it is the practice of law.
As a matter of fact, you, if I'm not wrong, you have the largest private biblical, help me out, something wonderful on your property.
Yeah, we opened up a theological library that's used by people of all different faiths. We've got we'll have at least 2 or 3 Muslims a week in the library because we have full resources on Islam as well. But it concentrates in Jewish and Christian studies, and we'll have 50 patrons a week. We've had Justice Scalia come lecture here when he was still alive. We've had countless other people who are in politics as well as in all walks of life come to the library. It's open to the public. It's not a circulating library where people check out books. It's a research library to be used by people in research. We've got at least 2 college universities that offer degree programs through the library and the learning center that's attached. And so it's a thrilling part of our life and a great joy to be involved in that as well.
That's wonderful. Okay, the matter at hand. I know you've given this some thought because this is what you do for your occupation, not your passion, but probably both. What makes a great trial judge?
Different factors come into this. And when you first asked me this question back in the day, I started trying to think through the various judges. And I can talk about things that make a great trial judge. And I can also talk about things that you might think make a great trial judge, but that I've determined really don't matter. So let me first, if I could take that luxury and talk about the things that don't matter so much about whether or not you're a great trial judge. So some people may say a great trial judge is a judge who lets the lawyer try their case. I'm not so worried about that in those terms. I don't think in those terms. And it's unusual because a lot of times when I'm in front of a brand new judge, like I tried a case in federal court in Ohio year before last, and that judge, I think, was a little wary of me because he thought, oh, here comes this hot shot who's tried cases everywhere and he's going to try and run my courtroom for me. And I need to make sure he understands he's under my thumb. I don't know that that was a conscious thought, but I often have that awareness that it would be understandable for a judge to think that way. In my mind, I think one of the things that judges do is they do own that courtroom. Every judge I've ever met has taken an oath to see that justice is done in accordance with the Constitution and laws of the United States and the various states in which they judiciate, if such is a word. And so the judge has a responsibility that she or he has taken an oath to do. And I think it's incumbent on the lawyer then to help the judge by learning where the judge draws the out of bounds lines. Every judge gets to determine the length and breadth of the field of play, if I could use a sports metaphor, in their courtroom. And some judges draw a very narrow field. The lawyers don't have a lot of room to play. Some judges draw a very wide open field where almost anything goes. That's the judge's determination. The lawyer's responsibility is to play within the field and the out of bounds that are declared by the judge. So a good judge, to me, is not necessarily one that gives a wide open playing field for the lawyer to do whatever the lawyer wants. The good judge is a judge who makes clear, here are the boundaries to my playing field. I expect you to play within that field. You can use all the fields you want within those lines, but those are the lines. And communicating those lines clearly and imposing them equally on all sides in the courtroom is going to make the better judge over a judge who simply doesn't care, or a judge who has lines but doesn't make them well known. So I think that the idea that a judge lets the lawyer try their case, in some ways I see that and agree with that, but in other ways I think it's very important for us to realize that's the judge's determination of how things are to be done in their courtroom. That's not the lawyer's determination. And so as a practical example, I'm going to appear, unless the schedule changes, 2 days from the time we're recording this, in front of a federal judge in the Southern District of New York that I've never been in front of. Now, I've met this judge through various judicial conferences. I've spoken with this judge on a panel, but I've never been in front of the judge. So what I did is I went on the website and I found that this judge has published the rules that he expects lawyers to follow on a public website. That's brilliant. Now I can read those rules and I know what this judge expects from lawyers. And I can even pick up more by the tone of the rules that he's got than simply the words on the page. And I'm able to go in and play fairly on his turf, which is the way lawyers should be. So I think a good judge is one that communicates, here's what I allow, here's what I don't allow, and then enforces it equally. And if a judge does that, and a judge recognizes that overwhelming drive that our system exists for justice, nothing more and nothing less, then you've got the makings of a great judge.
What are some of the examples that were on the website that, again, a judge that's listening to this podcast, what were some of the things you read that you thought that's really good and that's helpful in telling me where the lines in the field are?
So this is a judge who put on his list of things that you are always to address everything through the court, never address the other lawyer directly. So for example, instead of me saying, defense counsel, will you agree that we can do this and this? I don't address defense counsel. Instead, I address the court. Your Honor, if defense counsel will agree, then we will agree to do ABC. Just small little technical details like that. Now, that may not matter to a lot of people, but it's the judge saying, I want to make sure everybody understands that I'm the judge and I'm in control in my courtroom. So there's a subliminal message there as well. And that's one that directs me as a lawyer to make sure that I show this judge utmost respect. The judge has also put in there that lawyers should stand up when addressing the court. Now, I was taught to do that anyway, but I can't tell you how many trials I've been in where other lawyers in the courtroom don't automatically stand up to address the court. And oftentimes the court doesn't say anything about it, The court just lets the lawyer be the lawyer. But that tells me that this judge recognizes the reality of what the architecture of the courtroom shows, and that is that the judge sits higher than everybody else and is worthy of respect, commensurate with the responsibility that goes from sitting up higher. And so those types of instructions in the practice manual that you can get off the internet for this particular court really help me as a lawyer as I'm going in there. I've got the right mindset, I hope. And if not, shame on me. It's not the judge's fault.
What are some other things in all the courtrooms across America? When you finished a trial, you think, wow, I really like that or X that the judge did. Now, I want you to assume that they're brand new judges that are watching this. And so you're sort of, with your experience, telling them what really worked and it, works for the system.
Well, it's a lot easier for me as a lawyer the looser the judge is on, or the broader the playing field is. I was trying a case in front of a federal judge in Los Angeles, and I had a really, really good defense lawyer on the other side. I mean, this guy was out of Chicago. I won't use his full name, but his first name's Dan. He's a friend of mine. I don't know that Dan's practicing much anymore. I think he may be in retirement, but he's always been an amazing trial lawyer. So I was really excited to try this case. So we've got a judge, and this judge had been appointed by Jimmy Carter. So she had been on the bench for a long time. I think she was in her 80s, late 80s. She may have been in her early 90s, but she had been on the bench for a long time. She was one of the kindest, most soft-spoken, diplomatic people, but she clearly had a lot more experience than I did. When Jimmy Carter, I got my driver's license when she took the bench. So there was an age difference there. And Dan stood up at one point when I had my witness on the stand and I was questioning my witness. Dan stood up and said, "Objection," and didn't give the grounds for the objection. The judge said, "Sustained." I thought, well, I don't understand what I did wrong. I don't understand why that. And I thought, well, maybe my question was a little argumentative. I guess you could say that I had used a verb that might have been a little bit argumentative if you're really picky. So I reworded it using a vanilla milquetoast verb. Dan stood up and said, "Objection." And the judge said, "Sustained." I thought, now mercy, then it must not have been the verb. Maybe she doesn't think I've got an adequate foundation for this. I can't imagine, but maybe I need to ask the witness to assume something before the witness answers. So I said, well, let me ask it this way. Assume with me, and I set some assumptions, and then I asked the question again. Dan stood up and said, "Objection." The judge said, "Sustained." And I looked at the judge and I said, "Judge, I'm not trying to offend you or your court." I said, "I'm not quite sure what's wrong with my question, the basis of the objection." The judge smiled and politely said, "Mr. Lanier, I'm not your law school professor. I'm not here to teach you." And I thought, mercy. Okay, I got to figure this one out. So I stood up and I was still standing. I gave the same question, I think. I bet you it was almost word for word the same. Dan stood up and he said, "Objection." The judge smiled and looked at Dan and said, "Overruled." So the witness answered the question. We shortly thereafter took a break. We went out in the hall and Dan's just cackling in laughter. And I said, "Please give me a clue what your objection was beyond the first time." And he said, "Well, the first time it was argumentative." I said, "Okay." He said, "But once she did that, I just kept objecting. I didn't have any basis for an objection. And he said, that was hilarious. And I started laughing too. And he says, well, I'm glad you can laugh at it. And I said, well, I can laugh because I'm about to pass the witness and I'm going to do the same thing to you. And Dan went, why does he ghost? And he said, oh, okay, this is not funny now. He said, let's make a deal. We won't object unless it's obviously wrong. And I said, deal. And we shook on it, and the rest of the trial went fine. You know, I looked back and I wish that judge had given me some guidelines. I didn't understand her ruling. But I do think that she was going to be consistent and call it both ways. And if that's the way she runs her court, so be it. I've had other wonderful experiences. I don't put it to her age. I was trying a case in front of Judge Debevoise in Trenton, New Jersey. He was a federal judge there. Judge Debevoise at the time I tried the case was in his 90s. He had landed Normandy on D-Day +1. He had pictures in his chambers of him with Eleanor Roosevelt. He was an amazing judge. He came in for trial and he said, look, I get horrible feedback in my hearing aids if I have them on while the whole mic system is on in the courtroom. So as trial begins, for the jury to hear everything and the speakers to be on and the mics to be on, I have to turn off my hearing aids. I have real-time court reporting being done. So I will be reading everything that you are saying and everything the witness answers. So please understand that as I'm looking down, I'm not ignoring you. It's the only way I can know what's going on. Sounded great. He'd found a way that worked. Well, the defense attorney in that case is a case over retirement benefits. Okay. The defense attorney in that case quickly realized there's about a 7 to 8 second delay between the words that pop up on his screen and the words coming out of the mouth. So the defense attorney started doing speaking objections. Something, by the way, that judge next week, or I mean, this Wednesday that I'm in front of says none of. He put it on his list. Don't do speaking objections. But this judge wouldn't know it was a speaking objection. So my opponent would stand up and say, objection, hearsay. And then he'd start adding all this ad lib stuff. And when it pops up, objection, hearsay, the judge would sustain the objection or overrule it. But all this speaking stuff would get in before the judge could rule. Now, I don't object much during trial. I had 3 objections that entire trial. And I thought I would do the same thing. So I stood up the first time that I objected, said objection. And I set the basis and I started to give the speaking. And before I could get out a word of a speaking objection, the judge ruled. And he did that all 3 times. He ruled immediately after I stood up. And twice he overruled my objection, and once he sustained it. And after the case was over, I went back into chambers to visit with him on invitation. And he asked me what I thought about the trial and everything. And I said, Judge, did you sandbag us? And he said, what do you mean? And I told him what I just told you. And he said to me, he said, Mark, after watching you for a day or 2, I figured out you sort of knew what you were doing. So when you stood up and objected, I ruled guessing what your objection was based on what I would do if I were you. So I was just guessing before it even came up on the screen. He said, did I get my rulings right? And I said, Judge, you were 3 for 3. And he was. He even the ones he overruled, he nailed them. And he laughed. And so I just thought, what a delightful judge who has figured out how to work within his personal boundaries to get to where you need to be. And I really, really appreciated that with him. He's passed on now, and I regretted not being able to go to his memorial service, but such a marvelous judge. So, we've got judges that figure out ways to work, but still have that goal of letting the lawyers do what's reasonable within their courtroom. I've had some judges shut me down because they don't like PowerPoint. I've had some judges shut me down because they don't like this, that, or the other. I had one judge one time. This is a horrible story to tell on myself, but I'll tell it. I was set for trial in federal court in Louisiana, and it was in a small town in Louisiana. I think it was Lafayette, and I was a young lawyer, and I had driven in the night before and got to the Holiday Inn where I had stayed, and I had driven in my socks because I was just wearing socks and I wasn't too thoughtful about it. I often drive long distances in my socks, and I thought I had packed my dress shoes for court the next day, but I got up the next morning, I've shaved, I've showered, I've got my suit on, and I looked for my shoes. I didn't pack my dress shoes. And since I drove in my socks, I didn't have any shoes. I've got to be at court by 9 a.m. to pick a jury, and I have no shoes. I checked the phone, but there's a Walmart, but it doesn't open until 10. I got no place to buy shoes. So I sheepishly show up at court at 8:30. And the other side's there as well shortly. And I get the other lawyer, and I'm in my socks. And we go knock on the judge's chambers. And I said, Judge, and I just laid the story out in front of him. This judge started laughing, and he said, Lanier, I'll give you the option. You can stand up and voir dire, or voir dire, as they call it in Louisiana, in your socks, and explain it to the jury that you left your shoes at home and you're going to have to get some over lunch. Or you can start after lunch and get some shoes as soon as the store's open. And I said, Judge, I'd just soon start now. And so we did. I did jury selection in my socks and got shoes over lunch. And I was a baby lawyer. And I was so glad I didn't get fired at my law firm because the judge didn't report me, and life went on and life was good. So I've experienced judges who understand the human side of what we're doing, and the fact that we as lawyers aren't robots, and we're not always on, and we make mistakes, but we're doing the best we can, hopefully, in concert with the court to try to find justice. I mean, I could tell stories forever, but those are a few that give an idea in anecdotal fashions of not just the attitude, but the actions that have made for great judges that I've had the honor to be in front of over my years.
If I'm a brand new judge, just starting, and I'm watching your podcast, what are just some succinct, small or large tips that you would tell me that would end up making me more successful?
Rule number one is to practice your courtroom demeanor and rules the same way I hope that we would live our lives by I'll go preacher for a moment. It's called the golden rule: to do to others the way you'd like them to do to you. So treat the lawyers and treat the jurors and treat the witnesses the way you would like to be treated if you didn't have the robe on and you were wearing the shoes or socks of whoever it is in front of you. That goes a long way. And that means punctuality. That means graciousness. That means consistency, trying to be fair to both sides. That means knowing what you're doing, being prepared, knowing the issues that matter, knowing the issues that don't matter, trying to make sure the trial is done so it's only done once. If you need to take time to figure out what to do without committing error, take that time. If you're a young lawyer, it never hurts to have mentors, to find people who you can talk to and ask their perspective or advice. That's especially useful with older judges. Baby judge school is a really useful thing, but it also doesn't hurt. I mean, heavens, when 94-year-old Judge Debevoise calls the lawyers back into chambers afterwards and says, how did I do? How could I do better? And he's been on the bench since Ike. I mean, what are you going to do? Yeah, that's a judge who's always looking to up their game, even at age 94. So to start with the beginning of not thinking you know it all, but looking to learn as you go along, learn where you can. I think all of those things go to making a judge that is a gold medal, blue ribbon, award-winning judge.
As we wind this down, because of all of your experiences all over the United States, what are some things the judges should watch for that they should not do? That you've looked at that judge and thought, boy, that didn't show very high emotional intelligence.
I had a judge one time. It's the only judge I think I've ever, one of two judges I've appeared in front of who were viciously mean toward me. One was a magistrate judge that I had agreed to try a case in front of. And this magistrate judge, I added it up, and this is the way I remember it. It was a long, long time ago, so my memory could be fuzzy. But it was about a 3 or 4 day trial. It was a traffic accident, a trucking accident that happened in Arizona. And this magistrate judge ruled against me every objection during the trial. Every time the opposing side made an objection, which I counted at 23, she sustained their objections. I made maybe 5 objections. She overruled all of mine. She was viciously mean. Then I get up in rebuttal and I said, during the closing argument, the defense attorney made the point that my client was probably speeding. My client had a regulator on their truck that would not allow the truck to go faster than 60 miles an hour. There's no way my client was speeding. And I finished my rebuttal, and the judge said to the jury, Mr. Lanier just told you there was a regulator on the truck that kept it from going over 60. You're to base your opinion based on how you remember the evidence, but I've obviously been paying great attention this trial, and I don't think that testimony is there the way Mr. Lanier said it. I think he's misleading you. You can now go retire to the jury. So I was livid, and the court reporter, bless her heart, was also very upset. And the court reporter found for me where it was in the record that the testimony was precisely the way I said it. And I called the judge back out and had the court reporter on the record, and I showed the judge the testimony. And the judge says, well, it really doesn't matter. I told them to make the decision based on their memory. And I said, Judge, you have in this trial dug a grave for my client and me. And then you put us in a casket and you nailed it shut with all of your rulings. And then you jumped up and down in glee after my rebuttal. That's what I feel like right now. And you can disbar me or you can throw me in jail, but I am expressing frustration because I have never had treatment like this from a judge. And I can't believe you will not make this right with the jury. And she said, fine. I'll tell the jury that the testimony's in there. Well, I'm waiting. An hour later, she hadn't called back in the jury or anything else. And I called her out and I said, Judge, are you going to call the jury back? We need to. She said, oh, I just went back there and talked to them. And I was aghast over this. The jury came back about an hour or two later, gave me every penny I asked for. And I interviewed the jury afterwards, and I said, I was worried sick that the judge's attitude would be one where y'all would rule against us. And they said, well, we picked up on the judge's attitude early in trial, but your client's an African-American, and we just think the judge was a racist. Wow. I thought, wow, that backfired. And that was one of the worst experiences I've had in a courtroom. And I mean, that's with the win. But that was a judge who just didn't belong on the bench, in my opinion.
Right.
And I hope that she changed her ways and got to be better. And I'm sure I wasn't a perfect lawyer, and I'm sure I made mistakes, but I never understood that, I guess is the right way to say it.
Any closing thoughts? Good behavior, bad behavior for the judges that are watching this?
Well, that's not quite what my closing thought would be, but I've got closing thought, and
Yes,
here it
please.
is. Whenever I meet anybody who has served our country in the military, I always make it a sincere point to say thank you for your service to the country, because they deserve that thanks. And I always want to, without seeming obsequious, and since this is going out into the anonymous world of the internet, I don't think it seems obsequious, but I do always want to say to those in the judiciary, thank you for your service to our country.
Mm.
The Magna Carta laid a bedrock stone down in the 1200s that King John was going to be usurped of his throne if he didn't change some things. And one of those things was his failure to allow justice with a jury trial. When the American revolutionaries were trying to justify seceding from Great Britain, treason, if you will, they declared independence, citing various reasons why that independence was properly declared, among them being that the king was depriving the Americans of their right to a jury trial. A bedrock foundation of the American system is found in our Pledge of Allegiance: freedom and justice for all. The last three words of that pledge. And those words have been in the Pledge of Allegiance since it was first authored in the late 1800s. And they are critical. And so from my heart, I want to express appreciation to everyone who has donned the black robe and said they would take part in that holy and right job of securing justice for all in America. It's a bedrock need that makes our democracy great, that allows it to thrive and makes it a beacon in a world of injustice. So I'd close by saying thank you for your service to the country.
Well, it's lovely. Well, thank you for all the people that you've helped and taught, both in your religious capacity and your legal capacity. And you know, I'm a big fan. So
big fan of yours, Lisa.
Thank
Thank you for the honor of getting to talk.
Thank you. Thank you, Mark. And thank you to all the judges that are listening. Thanks. Have a great day.
That concludes this episode of What Makes a Great Trial Judge, part of the Lawyer Minds ecosystem. We hope you'll take some of these trial tips and incorporate them in your everyday practice to improve the litigation process for everyone involved. Please consider subscribing to this podcast and take some time to explore the other content Lawyer Minds has to offer. Your feedback and ideas are always welcome. Thanks for listening, and see you next time.